Now, there have been celebrations for quite some time, about a year and a half now, at various levels. Delhi to, in the Hyderabadi lingo, they say Delhi to Gully. Gully means a narrow lane. All over the country, people have been celebrating 75 years of the Constitution. What exactly are we celebrating is the question. It's one of those rituals, or is there anything more than that? Before we go into that, let us have for the benefit of the youngsters, this Constitution of ours was not written on a clean slate. To borrow an expression from late Justice Krishna Iyer, not on a tabula rasa, a clean slate. There was a background. For me and generations after me, most barring a few faces, I don't find anybody older than me in this gathering. What, Mr. Pural, is there anybody in the gathering? I doubt very much, more or less. Anyway, for most of us, if not all of us, we are born in the Republic of India under the Constitution. Before this, for a couple of hundreds of years, we were under foreign rule. For at least 100 years approximately, from 1860 onwards, this country, and my dear young friends, I'm sure as students of law by now, if you have covered the legal history, what we call India today was not completely under the control of the British government. Only 2/3 of present territory of India was British India. 1/3 was still under the control of various local rulers like the Nizam of Hyderabad, the Raja of Mysore, Travancore, Cochin, so on and so forth. 1/3 of the territory was not part of British India. For the 2/3 of the territory which we call today India, the British had established a system of governance. From time to time, I don't want to trouble you with all the history. For the present day's purpose, in the process of the evolution of the system, legal system, governance, the Government of India Act 1935 is relevant in the context of what we are talking about, 75 years of the Constitution. The present Constitution of India, it's approximately some 70% of the document is more or less a copy of the Government of India Act. There's about some exact 30, 25, I never calculated, approximately. Most of it is a reproduction of the Government of India Act. There are additions, there are a few deletions, that's a different matter. Now, what is it that the Constitution has given us in this country, in the Republic of India? The broad administrative system, based on a theory that concentration of power in the hands of either an individual or a single institution is detrimental to the liberty of the people. This was the theory on the basis of which all constitutional governance is envisioned. Nowadays, we hear a lot of talk about getting rid of the colonial past and colonial legacy. I always smile when I hear these words because it's more of rhetoric. This constitutional system itself is a colonial legacy. Before the colonial rule and the colonial legacy, we were ruled by small rajas, some 500, 600 rajas of this country. Each one was a constitution to himself. There was no division of power, absolute despotic monarchs. Some of them may be a little liberal, some of them little wise. That's not the point. But a representative form of government was not there. It is the colonial legacy which gave us this. Not that everything which is colonial is bad. You must always try to take even the great Indian poet Kalidasa says, whatever is in the past is not all good. Whatever is new is not always bad. The wise take the best of both the things. That is the spirit in which, if we have to have a healthy system, that's the spirit in which we must look at these things. There's no point in this rhetoric, colonial, discard it, do this, do that. That's all nothing. Now, how was it that the governing systems, we know the power of the state, ultimately what is the requirement of a state to maintain an orderly society? A society where people can live with dignity, at peace, without any fear of unwarranted interference from the fellow members of the society or outsiders, people beyond the society. This is the purpose of state. And in the process of providing such a system of governance to ensure an orderly society, this system of constitutional governance, detached from the whims and fancies of individual rulers, was developed philosophically. Essentially, the model which we follow, which we borrow from the Western Hemisphere of the world. There were theories which were propounded, accepted, they became default beliefs today. Nobody goes into this question. Why should there be a division of power between the various wings of the state? All of us know as students of law or lawyers that the power of the state is divided between three great branches of the government: the legislative branch, the executive branch, and the judicial branch. Why should it be divided is the first question. The fundamental belief is, over a period of centuries, in the last 3-4 centuries, that the distribution of power in between the three branches is better for the liberties of the people, because all of us see the glory in the executive branch. I think barring saints, most of us would perhaps love to be the chief ministers or prime ministers, because it's a very authoritative position. Well, please tell me if there is anybody who doesn't love to become the chief minister or prime minister of this country. Well, I'll salute him. Maybe he's a saint. The point is, because it's a glorious position. We see when people in office, big offices, chief ministers and prime ministers go, the kind of entourage that follows, the kind of adulation that the society heaps on them. Well, human nature is such, we would also like to enjoy and bask in that kind of a glory. But unfortunately, that glory comes with certain problems. In fact, the very famous statement of Edward Gibbon, a man who wrote that famous book called The Decline and Fall of the Roman Empire. Somewhere in the book he says, so long as mankind bestows greater applause on its destroyers than on their benefactors, the quest for military glory should always be the preoccupation of all exalted souls, it says. When we go to the streets, who are the greatest benefactors to mankind as a class? Forget about Tamil Nadu, Telugu, Tamil, India, Pakistan, all those things. Who are the greatest benefactors who have conferred greatest benefits to society? the scientists, Thomas Alva Edison, Alexander Graham Bell, so on and so forth, innumerable people, Madame Curie, innumerable. Did we anywhere find the statue of any one of these people? We don't find. We find the statues of Alexander, Aurangzeb, Ashoka, Harsha, well mentioned. But who are all these people? Without meaning any personal disrespect to any one of these people, according to the modern Telugu poet's history, each one of them was a butcher. They killed lakhs and lakhs of people. Well, in the name of something, in the name of protecting this, in the name of protecting that, in the name of protecting their own people. The net result, but you find we deify these people, we worship them, we glorify them. So long as mankind continues to do this, every one of us would like to occupy that place, be the ruler, enjoy that glory. Now, but at least the thinkers realized this kind of a glory and power concentrated in a single individual would not, in the normal course, be beneficial for the liberties of the people. So therefore, cut it down, reduce it, distribute it. The ruler must be answerable to somebody. Who is that somebody? The primary answerability in a representative form of government is to the legislative body. Notwithstanding all the glory we see in the great public offices of ministers at state level, central level, and the black cat commandos and so on, what is it constitutionally they are doing? All of you youngsters, what is it that these people are supposed to be doing? They are there simply to implement the law made by the legislative body, legislative assembly or parliament. They don't even implement, they only advise the chief executive, the governor. And then, the power is delegated further up to the Tahsildar level or whatever is the last office in the state. Maybe in Andhra Pradesh they are called the Mandal Development Office. I don't know where the whole Tahsildar system is still continuing in Tamil Nadu. Yeah. Okay. Or the local sub-inspector in the police station. But the fact that they have the authority, the executive branch has the authority to get the law implemented, confers it with a great degree of glamour, authority. And naturally people crave for it. And there is always a possibility of power being misused. This is a proven fact in human history for millennia. Wherever there is the concentration of power had always been misused. Therefore, the theory was developed that power must be divided, distributed among various organs. Three great branches of state machinery have come into existence. This is the background in which constitutional governing systems have been put in place. Before we attained independence and we became a republic, broadly the same system of governance was in existence in this country. What we call today the IAS and IPS officers were primarily the officers responsible for implementing the law in this country. There is nothing new under the Indian Constitution. It was in a different name. It used to be Indian Civil Service, ICS. The same system continues. The Constitution didn't really change it. We simply adopted it. Whether they should have adopted it or not is a different question. This is not the occasion for me to go into that. I'm not here to discuss a constitutional review committee. We're only taking facts as they are. I continue. The legal system which we have today, barring the Supreme Court, the legal system which we have today in this country existed for 90 years before the Constitution came into force, from 1860 onwards. There was nothing new in it. And so on and so forth. The only additions made in the Constitution is the distribution of powers between the union and the state governments. By the way, the division of the country, British India, into the old expression which all of us still use as central government, though the word central doesn't appear in the Constitution. Central government and the states today, what we call, or the provinces in those days. Old Madras province, Bombay, Calcutta, so on and so forth, various provinces. Power was distributed among these people for administrative convenience. The system has not changed except that there was a reorganization of the territory, the number of states increased, and for various reasons, that's a different matter, but it's part of the distribution of power system. The only substantial change that is brought about by the Indian Constitution is the introduction of a chapter of fundamental rights, of guaranteed rights contained in Part 3 of the Constitution. Under the British government and the colonial rule, under the government of India, there is no such provision. Now, when India became a republic, the framers of the Constitution believed that people must have these basic rights, inviolable rights, irrespective of whatever are their elected majority. Because in a system of governance, we hear very frequently, almost every day for the last 75 years, at least ever since I started understanding the world and the world of law and started new. There have always been claims, we are the elected representatives, sorry Mr. Ilangovan, we are the elected representatives of the people. Therefore, we are elected by the people, we got the majority. So, we can do no wrong. Whatever we say is right and the Constitution has nothing to do control us. This kind of a talk I have heard at least for the last 55 years, because before that I was a child. I didn't know. But I've been continuously hearing it by different people in different languages and in different contexts. This is exactly what the Constitution doesn't want to happen. There are certain core values which can't vary with electoral majorities. Whoever has the majority, whatever be the name of the political party, whatever be their political philosophy, whatever be the majority, whether it is a road roller majority or a slender majority or a coalition government, there are certain essential values, political values, human values, which can't be violated. The idea of incorporating a chapter on fundamental rights is that the right to free speech. Now, how much of it is being obeyed is a different thing. We'll come to it later. How the Constitution worked for the last 75 years, we'll come to it later. This is the purpose of the making of the Constitution, and particular. Otherwise, remove that fundamental rights chapter, I don't find there's anything much different between the Constitution of India and the Government of India Act 1935. This constitutes the soul of the Constitution of India. Now, it also presupposes ultimately governance in accordance with Constitution is not only following the letter of the law, but it's a constitutional culture. Culture has certain ingredients, and forget about the constitutional law and other things. When we talk about Indian culture or our Tamil Nadu's culture, we have certain practices, they are not written anywhere. There are certain things which are by tradition for generations, thousands of years, believed to be right and good in the context of the social system. Similarly, in implementing a constitutional system and governance, it is not always the letter of the law. I'll just give you one example. All of you would have noticed that judgment of Puttaswamy, Justice Puttaswamy judgment. The question there For the benefit of the students, I'm sure lawyers would have gone through the judgment. If some of my young friends have not gone through the judgment of Puttaswamy, the question is whether there is a fundamental right of privacy under the Indian Constitution. The state very vehemently argued that under the Constitution there is no fundamental right of privacy, because in the text of the Constitution you don't find the word, the right of privacy. Therefore it's not there, is the argument. Eventually the matter went before a larger bench of 9 judges, of which I was also a member. And the bench unanimously held there is a fundamental right of privacy. See, the reason is this, but of course judgment is there, you can read it, and there are different opinions given, conclusion is the same. Everything is not said in the Constitution. There are certain things which follow by a necessary implication from the text of the Constitution. The silences of the Constitution, one very, very fundamental example, even before the right of privacy question arose, right from 1950 in this country, courts have repeatedly held, society has accepted it, that there is a freedom of press in this country. This expression, freedom of press, is nowhere in the document, constitutional document. You read the text of the Constitution, freedom of press is not there. It was by an interpretative process the judiciary has found this right as an integral part of the freedom of speech. That is the source of the freedom of press. Independent. Similarly, not everything is incorporated verbally or textually into the constitutional document. No, this is only one example which I gave. So therefore, there are a lot of these implications. This constitutes the culture of the Constitution. How do we understand? If I may be pardoned, and may not be understood as boasting about my own judgment, only to just drive home the logic I am mentioning. In that privacy judgment I mentioned, don't read this Constitution as a document written on paper with ink. You read it as a document written in the blood of the martyrs of Jallianwala Bagh. You will understand the purpose of this Constitution. Just don't read the paper, and it is not like any one of those legal documents which we write, contracts between the parties or some promissory note dispute. It's not a document like that, it is something more profound. So every word, every concept incorporated in the Constitution must be understood with that understanding that is meant to endure for a long time, if possible for eternity. There is nothing eternal in this universe scientifically. Everything would disappear. But if we want to live in a dignified society, if we want our children to live a dignified life in this country, if we want the next generations to have it, if we don't want to be interrupted by a policeman on the way at his will, in fact, occasionally you find, some time back I received a message on WhatsApp. Somewhere in Madhya Pradesh, somebody was walking on the road, policeman caught him and saying, "Why are you not wearing a helmet?" This kind of, anything can happen. Why should a man walk? Well, tomorrow if the Parliament or the Legislative Assembly is pleased to make a law that even pedestrians are required to wear a helmet, that's a different thing. There is a law. Whether the law is constitutional or not is a different question. But so far there is no such law. Pedestrians need not wear a helmet. Only the drivers of two-wheelers are required. I understand some other jurisdictions, some other countries, even four-wheeler drivers are also required to wear helmets. Anyway, we have not yet come there. But pedestrians are such a... But then we know what all happens. That is the problem with power. Policeman, a small salaried employee, has power. Just imagine how much worse it would be as the power grows more and more in the hands of people who lack this constitutional culture in them to regulate those people. In fact, when the American Constitution was being prepared, there was a lot of debate that went on. 3 prominent men in public life those days published a series of articles expressing their views how the American Constitution ought to be in those days. And those papers eventually were collected and published in the form of a book. I don't know if some of you must have seen, book titled Federalist. I don't know if some of you have seen that book. In the paper 9 of Federalist, Hamilton, I think, 72, my memory is slowly receding. It says, if men were to be angels, it was a male chauvinist world by then. Men always included women. Forgive me, my dear ladies here. The statement is, if men were to be angels, no law is required to, no government is required to rule them. Because men are not angels. Just relax the power, all of us are capable of doing some wrong things, mischief. Some problem is always there. Such is human nature, we can't help it, that's how the creation is. So therefore a law is required. The next statement is, if angels were to rule men, no law would be required to guide them. The author of that article recognized rulers are also not angels, so therefore better structure their authority, create some discipline. This is the purpose which it forms a foundational principle of constitutional governance. Even those who are interested with this, ultimately all the MPs, MLAs, they are only our representatives. Each one of them, maybe every MP, we have 1 lakh or 5 lakh, 1 by 10 lakh share in your MP. Because all our votes constitute make him an MP or MLA as the case may be. He is just a representative. So therefore, please remind them always. I may not be understood as saying something against people in politics. I am only trying to drive home the logic. This is true with any public office, including the judicial offices, judges, at any level. Because before I was called upon to speak, some mention was made about my background. It was not just for fun I did all those things. I honestly believed that as judges, as holders of public offices, we are as much responsible as any other public office. We want, in fact, I said it on more than one occasion, we want the Prime Minister to answer the questions in the Parliament. And we want a country where any individual, yes, rightly, that small man with small pencil who is going to vote, has a right to ask the mightiest Prime Minister, why did you do this? You want the Prime Minister to be answerable. You want the Chief Minister to be answerable. You want the MLA to be answerable. You want the MP to be answerable. But to say that judges are not answerable to anybody, well, this is not consistent with the constitutional system. You are holding a public office, you are as much now, the parameters may vary, the procedures may vary in raising these questions, that's a different matter. But anybody holding a public office in a republic under the constitution is answerable to the people for the only thing is, judicial officers by default say, a lot of decisions are taken by the governments. A lot of laws are made by the legislative bodies, assemblies or parliament. Debates go on there. They discuss. Sometimes they don't even discuss. Simply the bill is passed by show of hands. But nonetheless, in the system, once the majority of the members of the legislative body approve the bill, it becomes law and we are all governed by it. They don't have to give reasons. The legislature never gives reasons. They debate the reasons. But then they are individual opinions of the members in the legislative body. The only default condition for judiciary is that for every order you pass, you give reasons. Reasons, not fanciful reasons, reasons which have some basis in jurisprudence, some settled principles of law. You must be able to sustain your judgment or support your judgment with reason. That's one reason which marks out the judiciary. Therefore, they are conferred with a little more of protection.